Yes, the court will call the case of Heaven Lambert versus Joshua Bussell. Case number 2019-006000-DP. For the record, Mr. Bussell this morning is appearing via Zoom from the Monroe County Jail, having apparently been arrested on a bench warrant issued at the request of the front of the court. Also appearing this morning is the Monroe County front of the court attorney Rebecca Hicks. Mr. Bussell, can you please state your name and current address for the record?
Joshua Bussell. I just currently moved. I'm not familiar with the address at this time, but I know it's room 109. I'm right off of Welcome Way, right across the street from Travel Lodge at Days Inn.
Okay, so you're living in a motel?
Yes, I have no other choice. I got evicted from where I was before to now I'm in this motel, and I'm trying to keep it to where I can have a stable place to live.
Do you have any pending criminal charges?
Not at this time, because this one was just when I got pulled over last night, the officer told me that this was the only warrant that showed up.
Okay.
And it kind of shocked me, to be honest with you. It shocked me.
Let's talk about a case that perfectly captures everything judges hate to hear and viewers love to watch. Today's courtroom isn't about some complex legal loophole or misunderstood paperwork. It's about responsibility, or more accurately, the complete absence of it. We got a defendant appearing from jail, shocked, to discover he has a warrant for unpaid child support. And if that sounds confusing, don't worry, because he's about to explain it using a greatest hits playlist of excuses: eviction, disability, lost paperwork, memory issues, medical claims, and just enough emotional appeals to see if something sticks.
I thought I had all my court proceedings taken care of.
I'm not sure why I would shock you, Mr. Bussell. If you have an obligation to pay child support and you're not paying child support, and you've not been in contact with the front of the court, there's probably a really good chance there's a bench warrant out for your arrest. So I'm not sure why you would be surprised.
Well, I thought I'm sorry. I thought I was getting everything caught up with all my court hearings. Okay. I thought I was literally caught up. That could have been my learning disability. I could have not forgot, but it could have just, I thought I did. I probably just didn't make a payment. I think that's what it is.
And even if you're disabled and you're unemployed, you contact the front of the court, they'll work with you, Mr. Bussell. But when you ignore an obligation sitting in your hands, bench warrant's issued. Ms. Hicks, can you provide the court some basic information in terms of the arrearages, last payment made, and so forth?
Certainly, Your Honor. This case has a monthly support obligation of $58 per month. The last payment received was June 2nd of 2022 for $50. The current balance is $1,886.90. Your Honor, Mr. Bussell was just incarcerated in December of 2022. On December 12th, you found him in contempt of court. It was a first finding. He was sentenced to 7 days immediate jail, so he has a 38-day balance.
I was
at that
also
time, Your
Hold
Honor,
on just a minute, Mr. Bussell.
Oh,
at that time, he was ordered upon his release to report to the front of the court, pick up the jobs list.
This is where the tone of the entire hearing gets set. The judge isn't being sarcastic for entertainment. This is judicial disbelief. When someone claims they're shocked to learn they have a warrant for unpaid child support, the court immediately zooms in on intent. Forgetfulness isn't a defense when the obligation is ongoing, documented, and enforced through repeated court involvement. Notice how quickly the defendant shifts from confidence to uncertainty. I thought I was caught up, maybe my learning disability, maybe I missed one payment. That vagueness matters. Courts look for patterns, not promises.
And then it's the next hearing that he failed to appear at, which was on February 7th. In between the hearing he missed and when we actually requested a bench warrant, he did find himself back in the jail. However, he was released from the jail again prior to the bench warrant issuing for him. He did not come to the front of the court. He has not made a payment. He has not had contact with his caseworker, Mark Grumman, regarding missing the hearing. So the bench warrant actually just issued for him, Your Honor, last week.
Okay, right. Now I understand.
Okay. Mr. Bussell, it wasn't that long ago that you were before this court in December.
I was in the
3 months
process
ago.
of moving. Yes, I was just in the process of moving and I must have forgot because I packed up everything, my calendars and my appointment book and everything. I must have forgot that I had another appointment. That is totally my fault. Is there any way that we can resolve this to where I can get home today, to where I can have this resolved immediately, to where I can have some type of contact information to reach out to somebody that would help me with my disabilities?
Well, Mr. Bustle, you've ignored the front of the court since December. You were given a notice in February. Let's assume you lost the paperwork. Okay, that's understandable. Why couldn't you come into the front of the court and say, you know what, I just wanted to touch base with everyone. Even if there was a bench warrant issue and you appeared, we would have canceled the bench warrant. But you've totally ignored this obligation, and you've not made any payments since June of 2022.
I had no income. I have no income.
How do you support first of all, are you disabled, Mr. Bustle?
I'm mentally disabled, but I don't receive disability.
Have you applied for Social Security?
I'm trying, but I can't comprehend the paper.
Okay.
I barely can read.
Now the excuses meet the math, and math doesn't negotiate. The monthly obligation here is $58, not $500, not $5,000, $58. And the last payment was nearly a year ago, when the court lays out a balance of over $1,800, plus a prior contempt finding and jail time. This stops being a misunderstanding and starts looking like a pattern. What's especially damaging is that this isn't the first warning. The defendant was already jailed once, already ordered to meet with a friend of the court, already given a jobs list, and already told exactly what to do next. Judges take second chances seriously, but they take ignored second chances even more seriously.
If you come in and talk with the friend of the court, your caseworker, they'll give you a list of employers that are screening for employees, and they can help you find a job that will tolerate your disability, alleged disability, Mr. Boss. Well, you've ignored this obligation. You've done nothing. So how do you currently support yourself? Public assistance?
My fiance is helping me trying to get back on my feet.
Good.
That's the only support I got left.
Okay. Well, so do you receive any public assistance, or your fiance supporting you?
I got state insurance.
Right. What about income? Do you receive any public? Do you receive unemployment?
If anybody gives me, no, it is if somebody gives me a cleaning job, somebody that will give me something that I can clean or something to do, then I can work. But every time I put an application in, nobody hires me. I don't know what the deal is. So I'm going to go down through another temp service and see if I can do that again.
Well, the front of the court, once again,
battling cancer.
Also, we went through this in December. Once again, the front of the court is a 4-page list of employers that are screening for employees. I can get a job today at Michigan Bar, washing dishes. Can you do that?
Oh, you know what? I remember that list. You're right. I remember that list. Because I do have that list somewhere, but I remember you handing it to me. Not you directly, but I remember getting it from you guys.
Well, the front of the court updates it every month. So when you get out of jail, you need to come over to the front of the court and get a copy of that list and get a job.
Yes,
there's some jobs you should be able to do with your disability.
It's hard with my disability.
This section is devastating for the defense, whether he realizes it or not. Missing a hearing is bad. Missing a hearing and then failing to contact anyone afterward is worse. The court isn't punishing him for being unemployed or struggling. It's reacting to silence. When someone disappears between hearings, doesn't call their caseworker, doesn't show up, and doesn't make payments, the court's only remaining tool is enforcement. That's how bench warrants are born. And notice the timeline. He was released from jail before the bench warrant issued. He had a window, time on the outside to show effort. Instead, nothing happened. No contact. No payment.
Well, there's jobs that you don't need to read. Like, say, washing dishes. Jack's Lawn Service is looking for people. Any event, get that job list. All right. Your fiance or your girlfriend can post a bond on your behalf. Is that correct?
No, she can't post bond. She don't have that kind of money. We just recently moved. We just spent about, let me think, about $300, $400 just in, she just spent, not me. She did, just in an apartment, and then we just got kicked out of there, and I had to get help from my dad to get a motel room because we had no money.
Okay. Can your dad post a bond on your behalf?
My dad's broke.
Okay.
I mean, how much would it be? I mean, I'm trying to come up with ways that would be able to help, but if I can get out today, that would help out big time, because technically I was supposed to have my visit today with my son, Junior. I'm in here.
Unless you can post a bond, Mr. Boss, that's not going to happen. You need to, your actions speak louder than your words. You keep saying, I'm going to do this and do this. You've done nothing since your last in court in December. You have 38 days hanging your head. So the court's going to pose some additional jail, but you can post a bond if you're going to be out of jail. But when you get out of jail, Mr. Bustle, you need to stop in front of the court, get a list, talk with your caseworker. They can help you. If in fact you're disabled, then you let your caseworker know that. Apply for public assistance.
Your Honor, I do need some help. I don't need any more jail time. If I stay in jail, Your Honor, I'm going to lose my home. I'm going to lose my son.
This is one of the most important moments in a hearing, and it's often misunderstood. The judge isn't dismissing disability claims. In fact, the court explicitly acknowledges that accommodations and assistance exist, but disability does not equal exemption. The legal standard isn't, can you do everything? It's, did you try to engage with a system designed to help you? Here, the defendant admits he hasn't completed applications, hasn't followed up consistently, and hasn't worked with his caseworker. That's the problem. The court repeatedly explains that help is available, including screened employers and support services. When someone refuses or fails to access those resources, the court stops seeing hardship and starts seeing avoidance.
You said you have no home. You're just renting a hotel, Mr. Bustle, and you're not going to lose your son.
That's the only home that's the only home I got. I can't lose that. I can't lose my son.
Okay. Well, you're not going to lose your son. Ms. Six, do you have any questions of Mr. Bustle?
No, Your Honor, I have no additional questions.
Nobody can afford that bond.
Mr. Bustle, once again, all you got to do is keep in contact with the front of the court. We'd work with you, but you've ignored things. The only time we see you is when you're picked up on a bench warrant.
I'm not ignoring nobody. Why are you sitting here saying that I'm ignoring you guys? I'm not. I don't receive nothing.
Mr. Bustle, why didn't you just appear personally before the front of the court sometime since December?
I've been trying. But
okay,
I'm
haven't.
battling cancer and a tumor inside my testicle.
Okay.
I barely can walk.
You're out driving around in a vehicle last night. You could have come to the courthouse.
It's not my car.
All right, Mr. Bustle, obviously you're not very convincing to this court. Ms. Hicks, what's your recommendation?
Your Honor, the front of the court would recommend 38 days jail, 7 days immediate credit for today. As according to the jail website, 3/16 is the rest date, or $500 bond to be released without serving the remaining 6 days, and then a return date of May 16th at 8 a.m. on my Zoom.
I can't do no more jail time.
This is where emotion enters the courtroom, and the judge shuts it down immediately. Bringing up visitation at the exact moment consequences are imposed is a classic courtroom move, and judges are trained to recognize it. The irony here is impossible to ignore. The defendant claims he needs to be released to see his son, yet the reason he's incarcerated is failure to financially support that same child. Courts separate parental rights from parental responsibilities for a reason. One does not cancel out the other. Emotional appeals might sway an audience, but they don't override documented inaction. The judge's response is firm because the court has to protect the child's interests first, not the defendant's convenience.
Mr. Bustle, if you can just reach out to your fiance and your dad, if they can put together $500, you'll be released today. You can be home for dinner.
They don't got that money, Your Honor. I don't know how many times I got to tell you. My brother was just in an accident. My dad don't have that kind of money. I just recently moved. I got no money. I'm broke.
I understand.
My fiance's not going to get money until the 27th. And that's when, either not the 27th, the 21st. She just filed her taxes, and she said that she's going to help me with making a down payment for my child support.
All right. Mr. Bustle, you could have avoided put yourself in this position by ignoring this obligation, ignoring the front of the court, not appearing on February 7th. Even if you lost the paperwork, I understand that. You could have checked with the front of the court saying, hey, I just want to make sure that everyone knows what's going on. I'm having a problem. I've got some disability problems. I don't have the income, but I'm just checking in with the front of the court. That could have avoided you being in the situation you're in. Is there anything you want to say before the court imposes a sentence?
I've been trying to call you, been trying to reach out to you guys. My phone
How
is
did you
not
do that?
working.
Okay, Mr. Bustle, how did you reach out to the front of the court? Tell me.
I tried to call repeatedly. There's
come
two
into the
numbers on my
courthouse,
SIM
sir.
card.
You only live a couple miles away. You could be into the
can't
court. You can come
walk.
into the courthouse.
Your Honor, I cannot walk. I am dealing with a split test.
This is the moment credibility completely unravels. Each new excuse directly contradicts the last. He couldn't call, but stayed at a motel. He couldn't walk, but was driving. He couldn't come to court, but lived nearby. Judges are constantly evaluating credibility, and inconsistency is the fastest way to lose it. Once the court believes it's being misled, patience evaporates. The judge isn't mocking medical issues. He's pointing out logical impossibilities. Courts don't require perfection. They require honesty. And by this stage, the defendant's explanations aren't just unconvincing. They're actively damaging his position. The record now reflects avoidance, contradiction, and refusal to take responsibility, which makes jail not just permissible, but inevitable.
All right, to Mr. Bustle, the court's going to follow Ms. Sick's recommendation. This is the sentence the court's going to impose. I'm not going to impose the full 38 days, which I could. You got 38 days you have had. The court's sentence is that you order to serve 7 days immediate. You give him credit for the 1 day you have served. So that's 6 days in jail, but you can be released immediately upon posting a $500 cash bond. So if you can post that this afternoon or tomorrow, otherwise you serve 6 days, then you'll be released, Mr. Bustle, and you're ordered to appear before Ms. Six at the front of the court on May 1st. I'm sorry, you said May 16th?
Yes,
Ms.
Your
Six?
Honor, at 8 a.m.
May 16th, 2023 at 8 a.m. Now we're going to put this in order. We're going to email it over to the jail. You get a copy before release. But when you get out of jail, come over to the front of the court. Get a copy of that 4-page job list. Talk with your caseworker. Let them know that the physical problems you're having. And if, as long as you appear on May 1st, you'll not go back to jail. You hold the key to the jail, Mr. Bustle.
Is there any way that we can work on something that we're not doing no jail time, please? I cannot afford jail time. I need to get back to my son. I can't lose him.
When you come back on May 1st, we can talk about that, Mr. Bustle. But again, this is reach out to your fiance. Maybe between your fiance and dad, they come up with $500. You can apply toward your arrearages. Not going to find the cost. You can apply toward
Nobody
arrearages.
has that, Your Honor, nobody has that money right now until the 21st when my girl gets her taxes.
Okay. Maybe
I
she's
don't
got a
have-
sister or other party they can reach out to. That's the sentence
She
of the
has
court,
no
Mr. Bustle.
family. She's an only child.
The court
I
hears you,
don't
Mr.
got a
Bustle,
lot
but
of
that's the
help. I
sentence of
don't
the
got a
court.
lot of support anymore.
Right.
That's why I'm trying to
We're done
rely on
arguing,
you
Mr.
guys to
Bustle.
help me.
Mr. Bustle, we're done arguing. You put yourself in this position. No one else but yourself. You could avoid it
Hey,
by
I'm
simply
trying to
appearing when required. Keep contact with the front of the court. Right, with that will conclude this.
At the end of the day, this case wasn't about cruelty or punishment. It was about accountability. The judge gave clear options: post bond and take immediate action, or serve the remaining jail time and comply upon release. Every step of the way, the court explained how this could have been avoided: communication, effort, showing up. None of those things happened consistently, and the consequences followed. The takeaway here is simple but important. Courts will work with people who work with the court. But silence, excuses, and last-minute emotional appeals don't replace action, especially when a child is involved.